Okay, I'm Deb Gordon. I am a civil rights and employment discrimination lawyer in Bloomfield Hills, Michigan.
So, can you tell me about the rights that this pregnant woman would have in the workplace?
Okay, so pregnancy discrimination became illegal at the federal level not until 1978. The sex discrimination laws passed in 1964, but pregnancy was not covered until the next decade. At that point, it became absolutely illegal to discriminate against a female in the workplace because she was pregnant. You can't treat her differently. And that was true at both the federal level and the state level. In the federal law, though, the Congress wrote in a religious exemption. And what it said in the law was that you cannot force religious institutions, including religious schools, to violate their religious principles. So, not just with pregnancy, but potentially with other things as well, the courts have acknowledged at the federal level that there are some religious institutions, maybe it's a church, maybe it's a hospital, as we've seen recently in some of the stuff coming around the Affordable Health Care Act, but you cannot force religious institutions to necessarily comply with every law out there if it's a violation of their freedom of expression. So that's the backdrop. Now let's move forward to the Marion case. They have decided, at least from what we know has been said, that they don't want this teacher at their school because she's pregnant. The courts have looked at this. This would not be the first case. And the courts have tried to figure out, is it pregnancy discrimination? Is it something that their religious tenets would protect them and say, okay, you guys get to make the call, or is it flat out old-fashioned discrimination, which they cannot get away with? I don't know all the particulars of the case, but I think in this case the teacher would have a shot at showing that this is maybe more sex discrimination than pregnancy discrimination, and let me explain that. If she says, it's really my gender, because you know why? There are male teachers in this school that potentially have engaged in non-marital sexual relations, but I don't see anybody coming after them, then the pregnancy issue may fall away and it may be old-fashioned sex discrimination. So that's something to consider, and the courts have looked at that. Is it just women that are being singled out? If Marion's view on this is a lack of our moral and religious code, then it should apply equally to men and women. The courts will not allow a religious moral code to be imposed only against women, generally speaking. So that's one possible avenue. The other possible avenue for her would be if her pregnancy is really just a pretext and that's not the real reason, and there's some other reason they want to get rid of her, which would be illegal, like she's a female, something like that. So that would have to be explored as well. I want to talk for a minute about the Michigan law. It's called the Elliott-Larsen Civil Rights Act. The Elliott-Larsen Civil Rights Act does not have the exemption built into it for religious institutions. So at the state level, the state law does not say if you're a church or you're a synagogue or you're a religious school, sex discrimination laws do not apply to you. However, the school could certainly raise their own religious discrimination, freedom of religion, U.S. Constitution argument to say this trumps the Elliott-Larsen Civil Rights Act, which is the state law.
Now, what about the fact that she is gay?
Okay.
How does that play in?
Let me talk about that. In Michigan, there is zero protection for anybody who is discriminated against because they're gay. That has been true in Michigan from day one. There is a state law called the Elliott-Larsen Civil Rights Act which protects people for the following reasons: race, gender, ethnic background, religion, marital status, height, and weight. Absent from that little list I just gave you is your sexual orientation. And nobody in the Michigan legislature has had the guts or taken it upon themselves to add to that statute sexual orientation. And I don't see it happening anytime in the future. So in the state of Michigan, if an employer wants to fire someone because that person is gay, leave aside the pregnancy issue, there's nothing that the person can do that's gay to stop themselves from being terminated. There are a few ordinances sprinkled around, like the city of Detroit would have an ordinance saying that city employees can't be terminated because they're gay, but generally speaking, there is no protection in the employment arena for anybody gay. Some states may have it. I'm guessing most do not, and certainly Michigan does not. Now, again, it's a little more complicated, Marion, and I haven't seen her contract. I don't know for sure what the Catholic Church's position is on whether or not they would employ somebody gay, or if that's some kind of violation of their religious code. I recently heard, I'm not Catholic, but I recently heard the Pope make a comment about accepting people that are gay, but something about not as long as people don't act on it. So I'm unclear with regard to whether being gay would be a moral issue. But generally speaking, in Michigan, there is no protection for that anyway. And so the only other possible claim here would be for breach of her contract, but I think they're just not renewing her contract, so that wouldn't come up either, if that makes sense. But so the two main takeaways for this story are her being gay gives her zero legal protection. I mean, it's unfortunate if the school is firing gay people. You know, I think most of us would agree with that. But there's no legal protection. And maybe people should be more aware of that than they are. I think people assume that a lot more is going on out there to give people protection than exists. So that's number one takeaway. Number two takeaway is pregnancy discrimination, generally speaking, is flat out illegal. Number three is, however, there's a religious exemption under certain circumstances only for religious institutions. And that may allow Marion to get off the hook. We'd have to know more about the facts. One final point I want to make is the courts have looked at what does the employee do. Are any of her duties what the courts call ministerial, in the role of a minister? From what I understand, she teaches chemistry, and that's obviously not a religious class, so that would probably help her case as well.